Right, I do think we can probably kick off. So good morning, everybody. Welcome to the second employment law update of the year. For those of you who don't know me, I'm Graham Damant. I will be facilitating this session. You'll see I've been joined by a number of presenters who I'll introduce to you as we progress. Just to remind you, for those of you who have not been to these before, that the purpose of these updates is to basically inform you of developments in employment law, the sort of latest developments. What we find with employment law is it's always evolving. There's always changes, there's always new developments. So with every one of these seminars, we're able to present to you an evolving framework, which you need to obviously take into account. But we also try to make it as practical as possible. So we try to find examples of things that you will encounter in the workplace on a kind of day-to-day business, day-to-day basis, and will help you sort of deal with these type of issues, so knowing where the law is going. Just from a housekeeping purposes, we are obviously virtual, and so you'll see that the chat function has been disabled, but you are able to ask questions using the Q&A function, and I will be monitoring that. I'll try to answer as many, well, not I will try to answer, I'll try to direct as many to the panel as I can, but there may be some that we don't get to during the course of the day, just depending on sort of time frame. We are going to work through to 10:30. It's a hard stop then. We may finish earlier than that, but it all depends on the content of the program. This will be recorded, so for those of you who want it, it will be available on our website late in the course of the day. From a program perspective, once again, we do have a very full program. We're going to be dealing with a whole lot of very interesting topics. We're going to deal with COVID in the workplace. We're going to deal with dacha in the workplace. We're going to deal with high heels in the workplace. We're going to deal with road rage, and we're going to deal with violence in the workplace. In other words, all the sort of typical things that you guys have to deal with on a kind of day-to-day basis. But without further ado, let's then turn to the first topic, which is on COVID and the latest cases and developments around COVID. I'm going to hand over to Talita Laubscher. All of you will be familiar with Talita. She's a senior partner in the practice. She's a specialist in many areas of law. She's an author of many books. She's an opera singer of note and various other attributes as well. So I'll hand over to Talita on COVID.
And currently I am trying to pass grade 5 with exams. Good morning, everyone. I'm really glad to be joining you, and it's great that you can be joining us on this session. COVID, somehow it feels surreal actually that we are still talking about this, but here we are. And I think what is most important is that we have seen some developments since the state of disaster was lifted, and most of the regulations were lifted, requiring mask wearing in public, limitations on gatherings, and those kinds of safety measures. From an employer perspective, there is, of course, still the obligation of employers to ensure a safe and healthy work environment. That requirement is enforced in terms of the Occupational Health and Safety Act, and that needs to be read together with the hazardous biological agents regulations, as well as the code of managing COVID in the workplace. Those pieces of legislation and the code has not been repealed, and that gives us the legal framework for ensuring a safe working environment for our employees, not only employees, also third parties entering the premises of the employer. The obligation to ensure a safe workplace is not only on the employer, but there is a statutory duty under the Occupational Health and Safety Act on employees to also ensure a safe workplace. And it is in this context that many employers moved to require employees to provide proof of vaccination or a negative COVID test if they wanted to enter the premises. Now, over the past 2 2 months or so, we have seen movement in that regard as well. There are quite a number of high-profile institutions that have now suspended their vaccine requirements. Well, this requirement to provide proof of vaccination or a negative test. Importantly, in most instances, the policy is suspended. The policy is not withdrawn or cancelled. And in most instances, these institutions reserve the right to reinstitute it should it become necessary. Hopefully it won't, but that is how they have approached this issue. The decision in many of these cases was taken with due regard to a number of factors. It would include the level of vaccination in that particular workplace by now. It would include the fact that our public health system is not overwhelmed anymore, and that the number of COVID cases nationally and provincially have decreased significantly. There is a recognition that COVID has not disappeared. There are still people contracting COVID. There are still people very ill with COVID, and there are people who pass away due to COVID. So it is something that is monitored very carefully, and that is why in many of these instances, the institutions concerned said, we are watching it and we can, in appropriate circumstances, reinstate our vaccine requirements. Also, in some instances, what these institutions say is there might be special circumstances during the suspension that we in any event require proof of vaccination. For example, big events where there are lots of people congregate, and they carve out this right for themselves to, in those circumstances, require proof of vaccination or a negative test. While it doesn't appear as obvious from the Code of Good Practice that the employer is required to consider objections based on constitutional grounds as opposed to medical grounds, that is, of course, something that an employer must do if it proceeds with its vaccination requirement. And that is because the Constitution itself grants people certain rights. And an employer that ignores those kinds of objections and doesn't have a proper response might find themselves at the end of an unfair dismissal claim. So that is, very broadly speaking, the state of the law on vaccinations and COVID in the workplace. Of course, it might be that employers still require mask wearing where that is indicated for that particular workplace, hand sanitizing, adequate space, those kinds of things. But that all depends on the employer's assessment of the risk internally. And that is very important, that risk assessment. And also, I think what this pandemic has taught us is that these risk assessments need to be watched very carefully. It's a living document. They need to be updated regularly with reference to relevant facts, science, and medical information. And yeah, that you then act accordingly and make sure that whatever measures you put in place are rational and that they make sense. And in that process, that you obviously involve your employees and consult with health and safety representatives and trade unions as you may be required under the code. So that is the broad overview of where we are. I can perhaps also just tell you about some of the legislation that we have been involved in. We've been very closely involved with the challenge to the University of the Free State's vaccination policy. There were actually 2 challenges in the High Court in Bloem. The one was withdrawn in April, and the other matter is still ongoing. And yeah, it remains to be seen whether we will get a judgment ultimately in that matter. But as we speak, that matter is still live, and we are hoping to have a hearing towards the end of the year in that. So then I'm going to move on to the most recent CCMA decision dealing with vaccine requirements. That is the case of Gomotso Chachu versus Baruch Medical. In that matter, the employer approached the vaccine requirement as an inflexible rule in its workplace. It said everyone needed to be vaccinated. If you can't be vaccinated, that is, you are no longer able to meet the operational requirements of the business, irrespective of your job. And then the employer would move to retrench employees. And it then said, well, we will retrench you with severance pay if you can prove that you have a valid objection. But if you cannot prove that you have a valid objection, then we will retrench you without severance pay. And this employee engaged with the employer and said, I object on medical grounds because 10 years ago I had an adverse reaction to a flu injection. And for this reason, I am objecting to the COVID vaccine. The employer asked for proof, which the employee provided from the doctor that treated the employee 10 years ago, and the employer rejected that. Off the employee went to the doctors recommended by the employer at Mediclinic, provided a medical certificate, but the employer said, no, thank you, this, we're not satisfied. Then the employee went to get another doctor who is a specialist, apparently in COVID matters, got a detailed report, presented that to the company, and the company said, sorry, you are retrenched and you are not paid severance pay. The employee then took that matter to the CCMA, and the CCMA, I think, got to the right conclusion, but didn't really give us much on the law, because you can just, hear that this was not a proper retrenchment. There was actually no consultation in terms of Section 189, and the fact that an employee is able to prove or not to prove that they have a valid objection actually has nothing to do with the payment of severance pay. So you can just hear, all the potential problems in relation to retrenchment law there. Secondly, the employer didn't provide a risk assessment or a plan. It just said, we have a rule, this is our rule, it's inflexible, you apply with it, you comply or you don't, and the consequence for non-compliance is very clear. No consideration of objections, no attempt at reasonable accommodation, nothing of the sort, just a very inflexible rule. So on the merits, one can see why this retrenchment had to be unfair. Then it is very interesting, the reasoning that the commissioner applied. And it looked at the validity of this rule to require employees to be vaccinated. And it said, well, there is no legislation requiring vaccination in South Africa. Excuse me, and there's a very good reason why there isn't such a rule, because that would be unlawful and unconstitutional. Then it looked at the constitutional rights that an employee might raise, and specifically Section 12 of the Constitution, which is the right to bodily integrity, Section 9, which is the right to equality, and then it looked at Section 36. And nowhere is there any analysis of the actual legal framework that we just spoke about, the Occupational Health and Safety Act, the direction that was in place at the time, the hazardous biological agent regulations, and the code of good practice. So the commissioner didn't appreciate the principle of subsidiarity, and that you actually test the employees' compliance or not, and the employer's response to these kinds of challenges with reference to the applicable law, and whether that is constitutional or not. You cannot just simply go and rely on constitutional rights. You need to look at the applicable legal framework and the applicable legislation that is regulating this matter. The commissioner didn't do at all. There is a long discussion about how unfair these vaccination requirements is, but as I say, from a legal perspective, we do not think that that is actually the correct analysis that was followed. What was definitely counting against the employer is that it didn't produce the risk assessment, which is very curious because in a previous case involving the same employer, they did in fact produce their risk assessment. But yeah, then the employee was vindicated in the sense that it was found that that retrenchment was unfair. The employee didn't want to be reinstated, and therefore compensation was awarded equal to 12 months pay. And yeah, that is the latest on CCMA case.
Thank you, T. So of interest in that particular case was that the employer chose to use retrenchment as a methodology by which to do the termination. As far as I'm aware, most other employers, in fact, every other employer has rather gone the incapacity route. And I don't know if you want to comment on that as being the more appropriate process compared to retrenchment.
Yeah, I think so. Graham, a retrenchment is a no-fault dismissal, and there are very specific parameters that are indicated in the definition of an operational requirement in the Labour Relations Act. It's technological, economic, and structural needs of the employer. In the case of someone that is no longer able to perform their work because they cannot comply with this health and safety rule, it is the employee's inability to comply with that requirement. It isn't, something to do with the job that, is changing, or the structure is changing, or the technological or structural needs. So for that reason, we have approached it, many employers have approached it as an incapacity. You are unable to comply with the health and safety obligation in the employer's work. And that also, lends itself nicely to this kind of engagement, because there's a consultation process required with the employee anyway. There is the need to look at alternatives short of dismissal, and ultimately, if that employee is dismissed, you are able to fill that role again with someone who can meet those health and safety requirements. Not as if this role is disappearing or is changing significantly. It's the duties and obligations in that role remain the same. It is a health and safety, it's kind of an external requirement that the employee cannot meet because of their particular obligation.
Yeah, thanks, Steve. So look, I don't think this particular case has any cause for alarm in terms of those employers that have chosen to put in place policies and have gone through the proper assessments, proper workplace rules, done the proper incapacity processes, made reasonable accommodation where it's necessary. This isn't like a turning point in cases that have all gone in the way of employers so far. That's my sense of it. Thank you for that. Yeah. All right. We then move on to the next case, which deals with the issue of where damage is caused by striking workers to an employer during the course of a strike action, and the employer's ability to have recourse in relation to those damages. It's going to be presented by Dube. Sibu is a newly appointed director in the employment department at Bowman's, and an absolute rising star in the employment field. We're going to see a lot of him in the years to come, and we may even see him at some point as a kind of Chief Justice. He's that kind of character. But there's Sibu, and he'll now present to you.
Thanks, Graham. So much pressure, my goodness. But yeah, good morning to everybody who's joining us this morning. It's always very difficult to talk after Talita, especially when she's talking about COVID, and you have a case that's really just technical in nature. But please do bear with me. I think it is quite an important case, even though it doesn't really give the answers that I'm really interested in, but it's still an interesting case nonetheless. And I think it will be interesting just to see what happens in this case going forward. So the case involves Massmart and Sakau. And essentially, Massmart has sued Sakau for damages that arose in a protected strike in the amount of just over 9 million rand. Having suffered that damage. So the parties in this matter agree that the strike was protected, and Massmart therefore contends that during the strike, the union, its officials, its members, they engaged in various acts, or their conduct was such that they did not strike peacefully. Their conduct amounted to certain violations of the COVID regulations that they had in place, and they failed to comply with the picketing rules. So that's basically the basis of why Massmart is seeking damages against Sakau in this matter. Now, in response to that, Sakau has raised an exception to the statement of claim that was filed by Massmart. And so this case right now just deals purely with the exception. And in raising its exception, the union has listed 5 points, or rather the union relies on 5 grounds. And I'll just try and go through those grounds in a summarized form, but they're quite lengthy. The first ground that the union relies on is that the labor court has no jurisdiction to entertain the Massmart's claim, because the damages arose from a protected strike. So essentially they contend that you can only claim damages where the strike is not protected, and therefore that this falls outside of the ambit of the LRA, and a delictual claim should be pursued in the High Court. So that's the first ground. The second ground is that the labor court has no jurisdiction to determine whether or not the union's members had engaged in conduct that was in breach of COVID regulations and the Occupational Health and Safety Act. The third ground, which the union ended up not pursuing, was that the statement of claim did not disclose a cause of action, or that the regulations which Massmart had relied on were actually the incorrect regulations. So they abandoned that argument and conceded that the regulations were correct. So the court doesn't deal with that one that much. The fourth ground was that Massmart had failed to properly plead its case and make averments listing the factors that are set out in section 68 of the LRA as factors which the court will take into account when awarding damages arising from the conduct that is being complained of. So the union therefore claims that in its statement of claim, Massmart should have actually listed each and every single ground and then pleaded why that ground is applicable to this case. And finally, the ground that was relied upon was that Massmart had stated that the conduct of the members was actually conduct that happened outside of the designated picketing area. So they contended that because the conduct had been outside of the designated picketing area, there was no responsibility on them to take any steps or take any precautions rather in regulating the conduct that is outside of the designated area. So the court then went on to deal with these 5 grounds, and I'll quickly just mention what the court's findings were in respect of each ground. So the court dealt with them from the last ground that was raised until and in ascending order. In regard to the first ground, the court held that, so this ground related to Massmart having failed to properly plead a cause of action, and that the union has no duty to take any steps because the conduct was outside of the picketing area. So Massmart's argument was that the union and its members were actually engaged in conduct that didn't comply with the LRA. And where that conduct took place is of no relevance, right? And so the union had a duty to ensure that the protesters actually remained in the designated areas, and they failed to do so. And that because of that, this is a claim that is competent under Section 68 of the LRA. The court agreed with this argument, and therefore that exception was dismissed. Now, regarding the claim that the statement of claim did not set out, the factors that are listed in Section 68 for a court to consider, the court basically found that, once a decision has been made, and should the court decide to award damages, then in determining the amount that is going to be awarded, the court will then consider those factors, but that Massmart was not required to actually plead those factors. So that ground was then also dismissed on that basis. The third exception, as I've already indicated, was not pursued by Massmart, so the court did not deal with it. The second exception that had been raised by Massmart related to the fact that the Labour Court has no jurisdiction to determine breaches of offences that are brought in terms of the Occupational Health and Safety Act, as well as the COVID regulations. And in dealing with this one, the court basically found that what Massmart was trying to do is establish the fact or the principle that during the protected strike, offences were committed. And these offences related to a breach of the regulations that were in place at the time. And as a result, this ground was then also dismissed. Now, the ground that the court spent some time determining related to the interpretation of, what Section 68 is, and that is whether or not the court actually has jurisdiction to award damages where a strike is protected. And in dealing with this, the court relied heavily on the submissions that were made by Massmart, and Massmart had relied on the judgment, a Supreme Court of Appeal judgment, involving NUMSA and Dunlop Mixing and Technical Services. And in this judgment, the SCA, had observed, among others, that as long as the purpose of a strike is peaceful and it's conducted peacefully in support of or in furtherance of a protected strike, the trade union and the participants in the picket fall within the ambit of the provisions of the LRA, and that such protection is not lost in the event that there is conduct which constitutes a transgression or an offense. So essentially, the court said that just because the strike is protected does not then mean that you are protected should you commit misconduct as an employee during that protected strike. And the court went into quite a bit of detail in reaching that conclusion. But essentially, the court finds that being involved in a protected strike does not give you the right to then engage in conduct that is against the purpose of a peaceful strike. And as such, all 5 grounds of exception that were raised by Sakau in this case were dismissed. The court hasn't made a judgment yet, or I don't believe there's been a judgment as yet, as to the main application, which relates to Massmart's claim for damages in the amount exceeding 9 million rand. And obviously, this will be an important decision for employers to consider, once it does become available, and hopefully we will be able to cover it when it is out and when we host the next employment law update. Thanks, Graham.
Thanks, Sibu, for taking us through that. Fairly complex, but I think the answer is fairly clear, is that ultimately if there's misconduct committed during the course of a protected strike, the Labour Court does have jurisdiction to award damages, and I think that that is made fairly clear through that. So thank you very much for that. We're going to turn on to a retrenchment case, and I think it's a constitutional court case, Talita, and you're going to talk us through that.
Yeah, sure. Graham, it is a Bala World matter. It's solidarity on behalf of members, and they instituted a claim against Bala World Equipment, Southern Africa. This was one of the first retrenchments that happened in the face of COVID. In April 2020, Bala World issued notices in terms of Section 1893, calling employees to consult with it in terms of its proposals to retrench employees. These employees were represented by various unions. Solidarity was one and NUMSA was the other. There were actually 2 challenges to the fairness of these retrenchments, one by Solidarity, one by NUMSA, and this one is the matter that was instituted by Solidarity. NUMSA was joined as a 5th respondent, and so was UASA as well, and some others. So what happened in this matter is that on the 27th of April, Freedom Day, the Bala World considered the potential retrenchment, issued a notice of consultation in terms of Section 1893, and on the 28th approached the CCMA to appoint a facilitator, because this was a mass retrenchment in the face of the state of disaster and the COVID pandemic. The facilitator was appointed, and it took a while for those facilitation meetings to kick off. But essentially in June, July, these meetings took place. There were various meetings where the requirements, the topics for consultation were discussed. The one issue that was a point of contention, especially for Solidarity, was Bala World's proposals in relation to selection criteria. Bala World had suggested that they apply a blend of LIFO together with their employment equity targets. Now, you will remember that the Code of Good Practice on Retrenchments permit an employer to take into account employment equity targets where the effect of applying LIFO might undermine the employer's ability to comply with its own targets. Often where there are retrenchments, it is the most recent hires that would fall to be selected, and in line with employment equity appointments, or well, an appointment in terms of the plan, that might then actually be your designated employers or employees that are retrenched. And that has an adverse effect on the progress that you are making towards achieving your targets and goals in terms of your employment equity plan. So that was their proposal. We will look at LIFO, but we may also take into account our targets. and that solidarity to defense. And they wrote a number of letters, and these letters were responded to by Barloworld. And ultimately, Barloworld took the view that it will apply this blended approach, and they issued notice of termination by the 1st of August. Now, that means already a consultation process of 3 months, and notice was August. And bearing in mind that this was a facilitated process, but Solidarity then took this issue to the Labour Court, and they brought an application in terms of section 189, capital A, subsection 13, and complained that there wasn't proper consultation. So they said the consultation process was flawed because Barloworld didn't agree with them in relation to their representations on selection criteria. The Labour Court then said no, there was proof that Barloworld had complied with a fair procedure and dismissed that application. In that Labour Court decision, the court made this distinction between procedural fairness on the one hand and compliance with a fair procedure on the other hand. And the court said procedural fairness as a concept is wider than compliance with a fair procedure. And that is what it is actually just required under section 189A13 to consider whether there was compliance with a fair procedure. And it found in this case there was, and it dismissed the case. Then Solidarity applied for leave to appeal, which was denied. It then asked the Labour Appeal Court for leave to appeal, which was denied, and then it went to the Constitutional Court. And the Constitutional Court said this is an important issue and it will entertain this case, but that is the path, how it got to the Constitutional Court. The court gave us important pointers in relation to what is required of an employer during a retrenchment process and how it will deal with challenges in relation to process in mass retrenchment. So the first thing that the Constitutional Court said that is very important is that an employer must consult with an open mind. It mustn't enter the consultations with decisions already made, and there must be proof of a willingness to respond to requests for information. There must be proof of serious consideration of the representations that are made. There must be reasons if the employer doesn't agree with the representations that are made. And in this case, the court found that that was there. You know, these requirements for a fair process were present. Then, in relation to procedural fairness in mass retrenchments, the court said the remedy is section 189A13. A party cannot come under section 191 or any other basis to challenge procedural fairness. You must come under section 189A, section 13. And that section comprehensively gives sufficient relief to parties complaining about procedural unfairness. The first potential remedy is that the court can compel the employer to follow a fair process. That will apply where notice of termination has not yet been issued. So you can see this consultation process is flawed. You can see the employer is not engaging with an open mind. The employer has already made decisions. You go under section 189A13 and get an order that the employer comply with the fair process, even before notice of termination is issued. If the employer already issued notice of termination and there are complaints about procedural fairness, you can get an interdict under section 189A13. And that will then mean that the employer is interdicted from proceeding with these dismissals until it has followed a fair process. And there is yet another remedy, and that is that the employer can, or the employees can, after notice of termination is given, approach the court for an order of reinstatement pending the following of a fair process. And that, the court said, deals comprehensively with your rights under procedural fairness. The court didn't appreciate this distinction between what is procedural fairness and compliance with the fair procedure. It said, okay, you know, maybe theoretically there can be a difference, but where a consulting party is complaining about the employer not following a fair process, this is the remedy. Well, the right of recourse is section 189A13, and we can deal with those issues under that section. In this case, the court said no. There was meaningful consultation. There was proper sharing of information in relation to the various proposals that were made. And the employer did seriously consider and did provide reasons in correspondence with the union in relation to its proposals on selection criteria. So the procedural unfairness case was dismissed. There is also a case in parallel where Solidarity is claiming that these retrenchments were substantively unfair because the employer applied selection criteria that were not agreed and that were not fair and objective because of this blended approach on selection criteria, LIFO plus employment equity targets. So it will be interesting to see how the court deals with that issue, but on the procedure that we engaged with the employees on this issue, that we listened to what they said and that we responded in writing as is required under section 189, that the court said was done properly by Honourable.
Thank you, T. I mean, very, very important case, and I think very useful for people to rely on in the event that you have to follow a 189 capital A process. Let's then move to the second retrenchment case, which deals with retrenching employees on fixed-term contracts, and it's going to be presented by Melissa Cogger, who is a senior associate in our Cape Town office and a senior associate in our virtual office as well. Thank you.
Thanks, Graham. Yeah, so I'm going to be discussing the Yeko versus Red Mining South Deep case. It's a judgment by the Labour Court that was handed down earlier this year in March. And in this case, the employer had a 2-year rail maintenance and upgrading contract inside the Goldfields operations mine. And it had employed Mr. Yeko to service that rail contract, and he was employed on a fixed-term contract. So the term of the contract was linked to the termination of the rail contract or if the rail project came to an end. So it was therefore tied to the happening of an event. The contract with the employer in Goldfields was then terminated with effect from the 3rd of January of 2017. And Mr. Yeko was notified that his contract would terminate earlier than this on the 15th of December of 2016. And he was issued with a 1893 notice, and a large-scale retrenchment process commenced in terms of section 189A of the LRA. There was no challenge that was brought regarding the procedural fairness of this consultation in terms of section 189A sub 13, and the trade unions were consulted throughout the process, and Mr. Yeko was not present at the consultation process. So his contract was terminated, and it was referred to as a retrenchment rather than the expiry of a fixed term contract. And as a result of this loss of the contract with Goldfields, over 120 employees were affected. Even though Mr. Yeko was informed that his contract would terminate on the 15th of December, he was verbally informed that his employment would be extended so that he could assist with clearing the haulage on the rail. And he did this until the 1st of March 2017. And thereafter, he was prevented from entering the mine premises, and Mr. Yeko considered this date to be his dismissal. A new contract was then awarded to another company, Flint, in December of 2017, and Flint employed 43 of the 120 affected employees. Flint also interviewed Mr. Yeko, but Mr. Yeko was unsuccessful in applying for a position at Flint. And then he referred a dispute to the CCMA. So at the CCMA, it wasn't in dispute that Mr. Yeko's employment contract was fixed, and it was linked to the existence and the continuation of the rail contract. But when it went to the Labour Court, the court held that ordinarily in terms of fixed term contracts, this is not a dismissal. It terminates by the effluxion of time or the happening of an event. And in this particular instance, Mr. Yeko didn't have a reasonable expectation that his contract would be renewed or that he was going to be employed on an indefinite basis. And even though the company intended to terminate his contract prematurely on the 15th of December, which was prior to the happening of the event, which was the termination of the rail contract with Goldfields, and that would have amounted to a dismissal, he only actually left the services of the company on the 1st of March 2017, and therefore it was not the expiry of a fixed term contract on the happening of an event. The actual date of a dismissal was the 1st of March 2017. So the fact of a dismissal was established, and the employer in that case then had to show that there was a fair reason for the dismissal, and it sought to rely on its operational requirements because there was a general need to retrench due to the rail contract being terminated. So there was a commercial rationale because of a loss of a service contract. And the court agreed that the dismissal was substantively fair. There was operational requirements being the loss of a business. And in relation to procedural fairness, this couldn't be challenged because it was a large-scale retrenchment and no application had been brought in terms of section 189A, capital A, 13 of the LRA. And the court found that his dismissal was therefore procedurally and substantively fair. Now, in this judgment, the court did actually make some very interesting statements in relation to the potential applicability of section 197 of the LRA, which is transfers of a business of a going concern. And in this case, the court didn't consider that section 197 was applicable. So the company did not transfer its rail contract to Flint as a going concern. There was no transfer of a business. And in this respect, the court noted that there's potentially a lacuna in the law in relation to tendering systems. Here, the company lost a contract that employed Mr. Yeko, and the court said that tenders being won and lost is not dissimilar to a business being transferred from one business to another business as a going concern. But in this case, it's a service contract that's been taken over and not a business being transferred, despite the fact that some employees were actually taken over by Flint. And the court commented that it's concerning that companies could use a tendering system to achieve its labor needs without actually triggering Section 197. And it was akin in substance to a labor brokering situation. It just differed in form. And the court stated that this may be a potential space for the legislature to find ways to curb the apparent defeat of the Labor Relations Act in tendering systems. And the court said that the drafters of Section 197 didn't contemplate the scenario of the loss of contracts. It only relates to the transfer of businesses as a going concern. And the courts had not been able to give Section 197 an interpretation to encapsulate this particular scenario, and that legislative intervention may be a solution. The court also commented that it's possible that Section 200 capital B of the LRA could be considered, which is where an employer includes one or more persons who carry on an associated or related activity or business by or through an employer, if the intent or the effect of that is to directly or indirectly defeat the purposes of the LRA. But in this case, it wasn't actually relied on by the applicant. And if the applicant had raised Section 200 capital B of the LRA, the court may have been able to consider Goldfields as the employer and may have been able to find that it was jointly and severally liable to comply with its obligations as an employer. But it largely came down to the way in which the case was brought by the employee. And in addition to this, Flint, the new contractor, was not joined in the proceedings. So the court didn't have submissions before it as to whether there was an obligation on Flint to appoint YECO. So the entire case brought by the applicant didn't actually relate to a Section 197 transfer. He brought it on the basis of an unfair termination of an expiry of a fixed term contract, alternatively dismissal for operational requirements. But the court did consider the potential applicability of 197 and made some very interesting comments as to potential legislative development in that area of the law. Thanks, Graham.
Thanks, Melissa. Yeah, sounds like a very creative judge looking for some sort of remedy way beyond what the case was about and venturing into suggesting legislative changes that I think would have a very dramatic impact on the entire contracting environment if they then bring sort of terminations of one tender, appointment of a new tenderer into the 197 section. And that would be very, very far-reaching and have far-reaching impact on employers. But be that as it may, I suppose judges are allowed to express views on where legislation ought to go. We just hope that the legislators aren't listening. Right, let's move on to the next case, which deals with dishonesty. And it's the Toyota case versus NUMSA. It's been receiving quite a bit of publicity in the newspapers and publications. It's going to be presented by Helen Wilsenach. Helen is a senior partner in the employment department. She's been newly appointed as the head of our department. So congratulations to her. And Helen, over to you. And we look forward to hearing about Toyota.
Morning, everyone. I think we're going to be short and sweet on this case. This is a case where Toyota brought a review application in the Durban Labour Court in relation to a finding by the CCMA that dismissal by Toyota of one of its employees on its production line, Mr. Njolo, was unfair. And the facts are very simple. Toyota has in place a compassionate leave policy over and above family responsibility leave in terms of the BCA, where if there is a death in an employee's immediate family, an immediate family is very clearly and narrowly defined in the policy, you can then access his compassionate leave as long as you produce a death certificate, and in some cases you'd also need to put in place, produce an affidavit indicating the relationship between the employee and the deceased person. Mr. Njolo was dismissed by the company on the basis that they found that he had dishonestly miscategorized the compassionate leave that he had applied for on 3 occasions in 2013, 2014, and 2015. He had applied for leave for the death of his mother on 2 occasions and for the death of his son on a 3rd occasion. And factually, after an investigation, what what transpired was that it was actually the death of his deceased father's second wife, and one occasion the death of his deceased brother's wife, so on another, or sorry, his aunt, and on the third occasion it wasn't his son. In the narrow definition of the policy, it was in fact his nephew. When the matter went to CCMA, Mr. Njola's his evidence was very crisp. He said that he was aware of a compassionate leave policy from a colleague that applied to immediate families. He came from the Zulu culture and he understood it in terms of his understanding of immediate family. He said culturally, when his father passed away, he assumed responsibility for his late father's wife. And similarly, when his brother passed away, he took responsibility for his brother's family and his son. He also explained that what the procedure was that he would go to his supervisors. He explained what he needed the leave for. He said he used cultural terms when he explained. His supervisors were also isiZulu speaking, and they put in the form on his behalf. And the arbitrator's view was this was not dishonest conduct. This was someone who understood a policy in a certain way and applied it. He had worked for the company for 17 years. He had no prior disciplinary record, and in the circumstances, a finding of dishonesty was inappropriate and dismissal was not an appropriate sanction. The company then took this on review to the Labour Court. And the Labour Court effectively just reiterated the point that this wasn't an appeal. They were looking at whether the arbitrator's decision was a reasonable decision. And in the judge's view, he found that the arbitrator's outcome was reasonable. The judge found it was reasonable on the basis that when you looked at the policy was 35 pages long, and kind of buried in the small print was this compassionate leave policy, which in this case the judge accepted hadn't necessarily been aware of the policy, and also accepted on the evidence that Mr. Njola genuinely believed that this was his immediate family that he was applying for. So the judge said this wasn't dishonest conduct and upheld the CCMA's decision. And I think as an employer and as companies, there's probably two takeaways from this judgment. There's been quite a lot said in the press. The first point just to make is that the judge wasn't commenting on the compassionate leave policy, wasn't saying that the actual wording of the policy was unreasonable. But what the judge did say, well, what the implication is, you cannot have this long, voluminous document kind of stuck away somewhere. You need to, especially in big companies where you've got people working your production line or manufacturing, you need to make sure that your employees know what the policy says, that it's explained to them and that they understand it. Because if you're going to say someone has breached a policy, you need to be able to show, especially in this kind of bespoke policy, that they were aware of it. Sorry. And the second thing I think that's clear is, even though that the judge didn't comment and say that the policy itself was too narrow, we live in a very culturally diverse country, and we can't, I think, as employers, ignore that the fact that our employees come from diverse cultural backgrounds. And when you are looking at whether an employee's conduct is reasonable or not, I think the takeaway from the judgment, and there's been other judges that have made similar points, is you've got to look at where the employee's coming from and look at their cultural paradigm and their cultural reality. And in this case, Mr. Njola genuinely, from his culture, he was stepping into the shoes of his brother and of his late father. So it wasn't a case of someone trying to misrepresent their family relationship, of someone lying about it. This was genuinely what he regarded as an immediate family member, and the employer hadn't clearly explained the policy in this case, is what the judge found. So yeah, Graham, I'm going to leave it at that. But I think for all of us as employers, I know lots of people at Bowman's, we will be able to find some of our policies on the intranet, or we haven't looked at them always, but I think as employers, we just kind of need to take away that we proactively need to explain policies to employees. And when you're looking at whether something is misconduct, you need to look at it in the country that we live in, and you need to look at it through a cultural lens of the employee as well.
Thank you. Very interesting case. Are you dealing with the next one of Mr. Burton as well?
I think that is Zawadi.
Yeah, it's me, Graham.
You, Zawadi. Okay.
Yeah.
Right. So the next presenter is Zawadi Dlamini. Zawadi is a senior associate in our Joburg office. He's a bodybuilder and a soccer player. And we hand over to Zawadi to do the presentation on Mr. Burton.
Thank you, Graham. You're a man of your word. I'll be delivering that brown envelope by close of business to you. Don't worry. Yeah, good morning, everybody, and thanks again for obviously making the time and being a part of this. I think the next case I'll be dealing with is essentially addressing inconsistent application of discipline, right? And I think we're all familiar with the principle that an employer must essentially apply consistent discipline when it disciplines employees, right? Put differently, if there are a group of employees who've committed the same misconduct, the employer is required to apply the same discipline in respect of all those employees, right? Now, the question is, what happens where there are a group of employees who've committed the same misconduct, but the employer decides to enter into a settlement agreement in respect of some employees and not the others? Can it do this? Essentially, that is the question that was before the court in this case, and the case being is Burton and others versus MEC for Department of Health in the Eastern Cape. Just very briefly, the facts of the case are this. The Department of Health essentially entered into a service level agreement with a company called National Airways Corporation, the service provider. And essentially the purpose of this agreement was for the service provider to provide emergency assistance or emergency medical services to the department using its own aircraft. In other words, it was required to arrive at medical emergency scenes, transport patients and to hospital facilities, and also treat the patients. And for all intents and purposes, it was required to do this on behalf of the department. Now, on a particular day, one of the employees of the service provider, acting on behalf of the service provider, traveled to Cape Town with officials of the Department of Health. And this trip was, for all intents and purposes, for business purposes. However, on this trip, the employee of the service provider extended an invitation to the official, and the official's name was Mr. Maharaj, and essentially invited him to attend a soccer match in Bloemfontein. And at that time, it was a Confederation a soccer cup in 2009, a year before the World Cup. And when he returned from the trip, Mr. Maharaj extended the invitation to other senior officials in the department, and all of which accepted. Right now, the material part of this offer was essentially that the officials would use the aircraft which belonged to the service provider to travel to Bloemfontein. As we know, the purpose of this aircraft was actually to provide medical emergency services on behalf of the department, but in this case, it was going to be used for entertainment purposes. So the officials went to the Bloemfontein, had a good time, watched the match, stayed in the night, enjoyed the entertainment and all the benefits, and came back, and the trip was never reported. Unfortunately for the employees, the media caught a drift of it, and it was essentially reported. And during a parliamentary meeting, one of the legislature or one of the members of parliament posed the question to Mr. Maharaj and said, "We read about this trip, what happened?" Mr. Maharaj tried to deny it, created a fabricated story, and essentially said, look, the trip was actually approved and we're allowed to go. In short, the matter was investigated, and it was found that all the employees who were part of it were accomplices, and they were effectively, being dishonest. Now, the important part of the case is what the department decided to do is it decided to enter into a settlement agreement with Mr. Maharaj. And Mr. Maharaj, as we know, is the main protagonist, right? It said, look, we'll get a mutual separation with you and you can resign. In respect of another employee, Mr. Maheshe, he was set to retire in 2 months' time. So what he asked the department, he said, look, I have done this, but just, allow me to enter into early retirement, and I can just walk away. The department refused, right? And then the third employee, who's also quite material in this case, is Mr. Nlesibe. Now, what he did was he entered into a plea agreement with the department in exchange for final written warning. Now, in respect of the other employees, they never received that an agreement. They were never, were required or given an opportunity to negotiate, and effectively they were found guilty of misconduct and were dismissed, including Mr. Maheshe, who's the guy who was refused an early retirement agreement. Essentially, the employees referred the matter for arbitration, and in short, at arbitration, the bargaining council said that, look, actually, you can't offer some employees a settlement agreement and not others. This essentially amounts to inconsistent application of discipline, right? So they found that the dismissal was procedurally fair, but substantively unfair. Now, at the Labour Court found, among other things, it said that it disagreed with the arbitrator, right? It said that it's very important for an employer to actually enter into a plea agreement or plea bargain with an employee, because essentially this allows you to get more evidence and establish a case against other employees, right? And this is a material distinguishing factor between that employee and others, right? Now, in respect of Mr. Maharaj and Mr. Maheshe, remember Mr. Maheshe is the guy who was denied early resignation. The Labour Court said those two employees were comparable. They essentially committed the same misconduct. Now, in respect to those employees, right, Mr. Maharaj was offered a settlement agreement and Mr. Maheshe was denied an early resignation agreement. You can't do that, right? So in respect of those employees, right, that application of discipline was inconsistent. The matter was referred to the Labour Appeal Court. Now, the Labour Appeal Court dealt with this matter very thoroughly, right? And again, just highlighted the legal principles relating to inconsistent application of discipline. It made the distinguishing factor, as we all know, between historical discipline and contemporaneous discipline. And historical discipline is, of course, what the employer has done in the past, or how it's disciplined employees in the past. And contemporaneous is how employees of, who've committed the same misconduct currently are treated. And it's very important to distinguish between these two things. And it emphasized the parity principle, which is you must treat like cases alike. However, it emphasized also that the parity principle is deficient in the sense that in some cases, you need to deviate from that principle, because if an employee in the past was found not guilty for misconduct in circumstances where they should have, and an employee presently should be dismissed, right? The parity principle will not apply, because sometimes, a chairperson in a previous hearing might have found a finding of not guilty by mistake or not really considering the facts. So you have to apply the parity principle with caution, right? Now, the court said that in regards to entering into a plea bargain, it said that you could enter into a plea bargain. It essentially agreed with the Labour Court and emphasized the need and necessity to enter into plea bargains to essentially help an employer establish its case against certain employees. And again, relating to Mr. Maharaj and Mr. Maheshe, they found that these two individuals are comparable, right? You cannot offer one a settlement agreement and another, deny effectively the settlement agreement. Now, the key takeaways from this case is this, right? Even when a group of employees, right, a group of employees commit the same misconduct, you can enter into a plea bargain in respect of some and not others, even when they've committed the same misconduct, right? And again, I imagine the admitting your guilt ahead of time adds as a mitigation, right? And you can argue it distinguishes the employees. And the second takeaway is that what we know for sure is that you cannot enter into settlement agreement with some employees and not others in circumstances when they've all committed the same misconduct. And essentially, that is the case.
Very interesting case. Thank you very much for that, Zawadi. Thanks a lot. So then let's move on to the next misconduct, which involves insubordination. And this is the high heels case, as I understand it. And I'm going to turn over to Ayanda Nkabinde, who's a senior associate in the employment department, who's going to present on this case. It's a case of Mofokeng and CCMA and others.
Yeah, good morning, everybody, and thank you, Graham. Although my introduction was not as lovely as Booz, but I won't hold you to it.
I won't mention your bodybuilding effort, Ayanda. I will.
So yes, the case that I am dealing with is Mofokeng versus Talita Minerals Pty Ltd and others. It is a review application which came before the Labour Court. And the reason that Graham calls it the high heel case or high heels case becomes immediately evident in the introduction, which, if you don't mind, I will read to you just the first 2 lines. The evil that surrounds this dispute is the wearing of high heels as opposed to flat shoes. It is a case that pits sartorial elegance against health and safety at the workplace. I found that to be quite an interesting opening line. So back in 2015, Talita Minerals, which is a mine, introduced a rule, and the rule was essentially that high heels, among other shoes, but high heels cannot be worn in the workplace. Now, the manner in which the rule had been phrased was somewhat ambiguous. It did not specify, on what parts of the premises or if it was the whole premises. So in 2017, an HR coordinator, Ms. Mofokeng, was observed wearing high heels whilst she was at the main office complex. So it's quite important that, she wasn't rocking up to the mining operations wearing high heels. This was just on the premises, but also in the main office complex where, the administrative and support tasks are performed. So about 9 days later, still in September 2017, the company decides to conduct a risk assessment. And as a result of that risk assessment, there's an outcome that high heels are found to be a risk, a safety risk in the workplace. And accordingly, a day later, the company amends their initial policy, and they say that only flat shoes may be worn on all premises. So there they try to clarify that it means the entire company premises, including the administrative offices and the support offices, etc. On the same day, Ms. Mofokeng is spotted again wearing her high heels. And this time she's summoned to her HOD's office and she's basically instructed to comply with the instruction to wear flat shoes only. Now, during that conversation, there's a slight back and forth. And basically she says that these high heels are quite important to her femininity and expressing her feminine identity. Nonetheless, and despite how strongly she felt about that point, she decided never to wear those high heels again, for the time being at least. And then a day after that conversation, the employer emails all of the employees informing them of the rule, essentially saying that you may not wear high heels or any other shoes that are inappropriate, and also stating in effect that if you do breach the rule, you may be dealt with in terms of the company's disciplinary policies and procedures. So perhaps chagrined by the employer's decisions, Ms. Mofokeng decides to start speaking to her colleagues. And I mean, she's still wearing her flat shoes, but she decides to start speaking to her colleagues and, trying to lobby them, essentially. Trying to get them in support of her cause. So a few colleagues, they agreed to assist, but quite soon afterwards, they all drop out. She also goes to one of her trade union representatives, trying to pitch this cause, and again, even the trade union abandoned her in her efforts. At this point, the employer became aware of what Ms. Mofokeng was trying to do. And she was charged for insubordination and incitement. And after a disciplinary hearing, she was dismissed on both charges. She then went to the CCMA, and the commissioner found in favor of the employer and said that the dismissal was both substantively and procedurally fair. Now, again, aggrieved by what she thought was a decision that was unfair, Ms. Mofokeng then approached the Labour Court, and she sought to review that arbitration award, which found her dismissal to be substantively fair. Now, this judgment, which was penned by Judge Moshwana, is quite a scathing judgment on the employer. And in dealing with it, he discusses the two charges separately. So on the point of insubordination, he seems to have three grounds for his reasoning. Now, the first one is perhaps the one that's perhaps easier to digest. And he found that lobbying other people in order to, express, in order to come against perhaps a rule is not necessarily a challenge against the authority of the employer. It is nothing more than an expression of dissatisfaction. He found that, what Ms. Mofokeng likely would have done after she had lobbied all of these people was to go and plead her case to management to relax the rules or to change the rules in as much as it related to her area of operations on the premises. And so the court basically found that there is a difference between, an expression of dissatisfaction and an actual challenge against the authority of an employer. And so that seemed to be the first ground for reasoning on the insubordination point. And then the second ground, which is perhaps slightly more curious. The judge equated Ms. Mofokeng's actions to strike action. So basically he had found that, she was exercising what appeared to be, her right to strike, or at least to gather people to strike. And in that there was a discussion, the judge sort of had a discussion with himself about whether an individual can exercise the right to strike on their own. And basically what he found, which is perhaps at odds with what our jurisprudence says, what he found was that the right to strike can in fact be exercised by an individual alone. And then the third part of the reasoning was that changing the policy was something that the Mines Health and Safety Committee had to do. And in this instance, the line manager was the person who had decided to go and amend the policy subsequent to the risk assessment. And what the court found, although the court didn't explicitly make a finding on this, the court said that in those circumstances where the Health and Safety Committee had not convened to review the policy and implement what was essentially a new rule, this may have been unlawful. And if it was unlawful, then there would have been no insubordination because there would have been no refusal to obey an instruction that was lawful and reasonable. So that was the finding on the insubordination point. And then also perhaps what's important to mention is that the court went further and it said that even if this employee is guilty of insubordination, there is quite an important mitigating factor. The court said that by changing the rules as it did, just 9 days after she had been witnessed wearing high heels, the court found that the employer had in fact provoked the employee. And that provocation justified the employee's response. And in essence, the finding would be that dismissal would be too harsh a sanction. That's in the event that she was guilty of insubordination, which of course the court found that she wasn't. So I mean, that's quite an interesting point, to say the least, on the insubordination aspect. And then in respect of the incitement point, what the court found, or how it defined incitement, was as an individual coming and influencing people's minds in furtherance of committing a crime. And again, what the court did was attach what Ms. Mofokeng was doing to the right to strike. He found that, in the event that, this was in furtherance of strike action or something like that, then it would not be in the furtherance of a commission of a crime, and therefore it could not qualify as as incitement. But in any event, there was no evidence to indicate that she was intending to embark on strike action. Again, what it seemed to be was that she was just going to go plead her case with management and try to, give some input on perhaps how the rule can be amended. So yes, it's quite an interesting case. It will be interesting to see if some of the decisions or the grounds on which it was decided would be taken on appeal. But yeah, that concludes the Mofokeng case.
Thanks, Ayanda. Yeah, very interesting case on a one-man strike. I think you're also going to present on the second misconduct case, which is the Paul Coldset and Singh case, if I'm not mistaken.
Yes, that's correct. So yes, as Graham has just pointed out, as I quickly look for my notes, the case is called Paul Coldset Pty Ltd versus Sir Singh. And again, this is also quite an interesting case. It in substance, well, it's an LAC case, and where it began was in September 2016. And on an early September morning, Mr. Singh had ended his night shift and he was exiting his place of work, being Paul Coldset. And as he was exiting, it's end of night shift, so it's not too busy, not too much traffic. He decides to use the one-way road, which is for the people coming into the building. So as he does, he is confronted by an oncoming vehicle, and he is then forced to reverse and let that car pass. Now, in that car are two individuals. There's Ms. Kasim and her son. They are not employed by Paul Coldset in this matter. In fact, Ms. Kasim is employed by Media 24, who are fellow tenants in the building. Now, Mr. Singh does not take kindly to the vehicle coming on the correct side of the road. And what he decides to do is he causes a scene. In fact, he goes ballistic. He starts hurling insults and he swears at the Kasims. He kind of speeds, or he goes toward them at speed as they're exiting their vehicle, hurls more insults at them, to the point where Ms. Kasim understandably is reduced to tears. So on the same day, Ms. Kasim decides to take action, and she goes to the employer and explains what happened. So immediately the employer launches an investigation, and the employee is eventually charged, firstly with failing to adhere to safety regulations, and then he's also charged with violence and intimidation. Now, at the disciplinary hearing, the chairperson finds him guilty, but the chairperson decides that dismissal would be too harsh a sanction in this circumstance. So he decides that the correct approach, or in fact, what would be more appropriate, would be to issue a final written warning, provided that Mr. Singh apologizes to the Kasims for his conduct. So about a few weeks later, Mr. Singh, he addresses an email firstly to his line manager, basically setting out a very sort of stiff apology. And his line manager amends it, and basically after a back and forth, it's agreed that they will meet face to face with the Kasims to discuss what had happened in order to provide Mr. Singh an opportunity to apologize to them. So the day of the meeting comes. The Kasims, eager to hear an apology, are there on time, but they're made to wait 20 minutes by Mr. Singh. But it gets worse because Mr. Singh is in no mood to apologize. He says that, you know, he's obtained legal advice, and so at this stage, he's not going to apologize. He refuses to look them in the eye, and he just, you know, he's largely disinterested in the process that he had agreed to partake in. And of course, the Kasims leave that, they leave that meeting distraught and disappointed. And so afterwards, Mr. Singh decides to appeal the ruling in the disciplinary hearing, and the appeal is subsequently dismissed. So the company took a long, hard look at, you know, Mr. Kasim's conduct, and they decided that they would charge him again. And basically, this was on the basis that they thought that Mr. Singh's refusal to apologize, it escalated the conflict, and it also had the effect of bringing the company into disrepute. And this time, the chairperson said that Mr. Kasim is guilty of misconduct. He did breach the trust relationship between himself and the company, and as a consequence, dismissal was the appropriate sanction. So, of course, Mr. Singh then took the matter to the CCMA. And the CCMA basically found that the dismissal was substantively fair. And they said that, you know, by not apologizing at the meeting, Mr. Singh essentially did is escalate the conflict. He did bring the company's name into disrepute. And then again, Mr. Singh took the matter for review to the Labour Court. Now, at the Labour Court, the judge found that the sanction was quite harsh. Because their anger was directed solely at Mr. Singh and not the company, it could not be said that the company had been brought into disrepute. It was also stated by the Labour Court that, in effect, in this kind of instance, reinstatement with back pay would be more appropriate to grant, and so the Labour Court reinstated the employee on the basis that there was no actual disrepute that was brought upon the company in this case. Now, the matter was then taken to the Labour Court, the Labour Appeal Court, where the company sought to appeal the judgment of the Labour Court. And it's always interesting when we have a split decision in the LAC, and this is exactly what happened in this instance. Now, the company before the LAC essentially argued along the same line. So they made the same submissions that they had been brought into disrepute, and also that the trust relationship had been broken by Mr. Singh's conduct. And in this instance, the fact that, you know, he had served 33 years at the company, which was one of his mitigating factors throughout, simply could not save him. Now, Mr. Singh's counsel, on the other hand, argued that, the conduct actually was not that bad. He essentially sought to downplay it before the LAC. And in making its decision, now, I think perhaps what's crucial is to go back to the basics. This is a review application, the review of an arbitration award. And obviously, as we all know, the primary consideration there is about the reasonableness of the award. It's whether an arbitrator in the same decision, in the same position as the arbitrator deciding the dispute, could come to that decision. And in effect, what the Labour Appeal Court found, or what the majority found, was that the Labour Court, in determining the reasonableness, the Labour Court had actually treated this as an appeal and not a review. So they didn't decide it on a consideration of the evidence that had been placed before the commissioner. Instead, the Labour Court seemed to determine it on its merits and pretty much, in the same manner as an appeal would be heard. So the majority of the Labour Court found that the conduct was extremely serious. And looking at the timeline, initially, after the initial disciplinary hearing, the employer decided to make use of what's called progressive discipline by issuing a final written warning, and of course providing Mr. Singh with an opportunity to apologize. But the applicant's conduct in the meeting, the same contempt with which he treated the Kasims, was similar to the manner in which he had behaved, or certainly showed the same attitude as he had shown in the parking lot. And overall, by not apologizing, by not seeking to remedy the situation, Mr. Singh had breached the trust relationship with the employer. Now, as mentioned, there was a minority judgment, and in broad terms, what was more important to the minority was that the applicant had not been directed as to when he was supposed to apologize and where he was supposed to apologize. So when he had refused to apologize during that meeting, he had every right to do so. And he could have apologized at a later stage pending the outcome of the appeal ruling. It was also that he was acting on legal advice, which, as an individual, he was entitled to do. And then finally, the minority judgment also found that the Kasims were not employees and they were not business associates. So there was actually no disrepute that could be attributed to the employer. And that's just in broad strokes what the minority seemed to focus on. But yes, that is the Paul Coldset case. Another interesting judgment. And yeah, thank you very much.
Thanks, Ayanda. Yeah, it just shows how different people can come to different conclusions based on the same set of facts, and how sometimes some of these cases are very hard to call in relation to what is going to be the eventual outcome. Right, then let's move on to the next case, which deals with cannabis in the workplace. And Sibu, you're going to present on that.
Thanks, Graham. I'm not sure why this case was assigned to me specifically, but it's definitely not a reflection of what happens in my home. So this is quite an interesting, very recent case, and it involves Miss Eneva. The employee was employed by Barloworld as a category analyst, and I think this becomes somewhat relevant. So her role was really a desk job. According to the evidence that she led at the CCMA, she had suffered a history of severe constant migraine and anxiety, and her doctor had prescribed medication to her which was quite heavy, and it had previously caused her quite bad side effects. So when the consumption of cannabis for private use was decriminalized, she then started weaning herself off the medication by consuming cannabis at home. And she said that she was using the cannabis as well as cannabis oils to really help her with her anxiety and her severe migraines. She would also, of course, on the side, consume cannabis for recreational purposes. So Barloworld has a zero tolerance alcohol and substance abuse policy. And the reason for this, it's because of the dangerous nature of Barloworld's operations on its premises. Now, the employee has always been aware of this policy. So we're not dealing with the situation where the employee did not know what the policy states. And in terms of the policy, essentially, each employee, when they present themselves to the workplace, they are tested. They have to submit to a medical test. And this is what happened in the case of the employee in this case. She had to take a urine test. And when the urine test came back, it revealed that there was cannabis in her system. Now, she didn't present as someone, who was under the influence of cannabis or any other substance, but this test was conducted as general practice. And because the test came back positive, she hadn't consumed cannabis that morning or on her way to work. She had consumed over the weekend. And so because cannabis works differently compared to alcohol in that it stays in your system for quite a while, her test came back positive. And in terms of the policy, if the test comes back positive, you are then removed from the premises and you are asked to go back home. Now, because when she was removed from the premises on that day, she was placed on sort of a 7-day period so that she could, I'll say sober up. And I'll say that very loosely, but it's a 7-day cleaning up process to enable the cannabis out of her system so that she can be allowed back into the workplace. So she was given these 7 days, and when she came back, she tested positive again. And this was the case with her because she refused to stop using cannabis at home. And as a result of her continuous consumption of cannabis at home, she would therefore always fail and would always be in breach of the policy. And so Barloworld decided to charge her for her breach of policy. And at the hearing, Barloworld was actually requesting a final written warning. But because she insisted that she was not going to stop, the chairperson found that dismissal was more appropriate in this case because she is constantly going to be in breach of the policy. And so it actually serves no purpose to issue her with a final written warning. Now, at the Labour Court, she then referred the matter to the Labour Court, but her referral to the Labour Court was one for unfair discrimination on an arbitrary ground, right? So that was, she stated that her dismissal was automatically unfair, that she had been discriminated against, and that such discrimination was on an arbitrary ground. Now, we know that if you say that the dismissal is based on an arbitrary ground, the onus shifts onto the employee. You have to say what that arbitrary ground is, and it becomes more difficult. But essentially, the Labour Court went on to find that this is not a discrimination case, but rather a breach of policy case, and that she should have treated this as a simple misconduct case, thereby referring the matter to the CCMA for a claim for unfair dismissal. This wasn't a case that should be referred to the Labour Court as a court of first instance. Now, in reaching that conclusion, the court had a few considerations, and I'll just mention some of them. Firstly, the court found that, she had not been treated differently, right? The policy was applicable to each and every single employee. So any employee who was found or who tests positive for alcohol or a particular substance, they will not be allowed onto the premises. The position with which you are employed in is of irrelevance in this instance. So it was found that the policy was applied consistently. She had not been singled out. It was found that the policy did not differentiate amongst the employees. So there was no differentiation, which is essential for an unfair discrimination case. The court also found that, because she had stated that she smokes cannabis recreationally as well, she can't then, use the medical condition as a justification for her smoking cannabis and wanting the employer to therefore absolve her from smoking cannabis for medical reasons. And finally, the court found that Barloworld's environment is quite dangerous, and Barloworld is entitled to discipline and dismiss any employee who uses cannabis under the influence whilst at work. And so her referral was therefore dismissed on those grounds. And I think it would have been interesting if she had actually gone to the CCMA and the commissioner was actually required, to look at the reasonableness of the policy, because I think the danger in, the policy as it's currently crafted, and this is a remark that the judge made, is that it could be that the policy actually limits people's constitutional rights to consuming cannabis in their homes, because if you consume at home, you're always going to test positive at work. So, that's a remark that in fact, he actually said, the judge actually said, the policy may very well be unconstitutional, but unfortunately, it's not discriminatory. And so it would be very interesting to see what would have happened if, the proper case had actually been referred. And I think the important thing to note here, for all employers in substance abuse policies, it's very important how you're actually going to carve out, a situation like this one, because you don't want your policy to be found to be unconstitutional, but at the same time, you want to make sure that people who are in the workplace, where it is a real risk for them to be under the influence, are not under the influence. But yeah, I think let me stop there. That was the cannabis case.
Thanks, it'll be very interesting. Melissa, we're going to turn over to you to deal with the zero tolerance and threats in the workplace case, which is the Masondo and AG Electrical case.
Thanks, Graham. So this is a CCMA case that was handed down in December of last year, and it dealt with a WhatsApp message that led to the dismissal of an employee. So in this case, due to the COVID-19 pandemic, there were restricted work opportunities at AG Electrical. And after consultation with the relevant bargaining council, the unions and the representatives, it was decided that the employer would implement a short time policy. So all employees were informed on a daily basis as to who would be working, and the work was divided evenly between the employees. Now, the employee in question sent a somewhat incomprehensible WhatsApp message to a WhatsApp group where all the employees were participants in. I will read it for purposes of the presentation. And it said, "Think EFF can help us all when someone is trying to fool us. Those two guys from church, we never call union, us to meeting, so is fine. We didn't kill that stupid, so I will try to the Zulu nation. What going on? Those guys, they total commit crime dilemma. Must know this by Tuesday. We still organizing Pella. We can lose our money. Someone want to run with our money." The message is quite cryptic, but unbeknownst to the employee, the CEO was also on the WhatsApp group, and he read this message. And the employer was of the view that this message, although very difficult to understand, included direct and implied threats of physical violence and death. And obviously it was in relation to this employee's dissatisfaction with the introduction of the short time policy. So the tone was one of violence and encouraged violence amongst the other employees. And the employee was then charged with intimidation for sending a death threat to the WhatsApp group and for insulting, abusive and obscene or threatening behavior towards the employer. Also that he had made unfounded accusations towards the employee on the WhatsApp group, and that such actions were detrimental to the interests of the employer in that it disrupted the harmonious work environment and it affected the employment relationship detrimentally. The CCMA found that the main charge was actually just one of intimidation, and all the other charges all flowed from the main charge. And there were two conflicting interpretations as to what the purpose of the WhatsApp message meant. In the end, the commissioner agreed that whilst the WhatsApp message was incomprehensible in many respects, it did set a tone for violence, and it did encourage violence amongst other employees. And the reason for the short work was a legitimate attempt by the employer to set in motion a procedure to implement short time after consulting with employees, the union, and the bargaining council, and it was implemented as an attempt to save jobs and to avoid retrenchment. So it was understandable that the employee was disappointed in having to work short time, but his response was disproportionate and uncalled for. And the commissioner held that the employer couldn't be faulted for adopting a zero tolerance approach to the threat of violence, including a death threat. Even though this was a first offense, it was in the interests of workplace harmony and the safety of its employees of others that this employee be dismissed. To adopt an alternative approach would have set a precedent that this type of behavior was acceptable and would be tolerated. So as a matter of policy alone, the CCMA found that the sanction of dismissal was entirely appropriate and was the only proper sanction in this case, and the dismissal was procedurally and substantively fair. Thanks, Graham.
Thanks, Melissa. Zawadi, apologies to you. I'm just going to jump to the last case of which Sibu's going to present on, because I think it's quite important, and then we'll come back to you if we can. There are also just a couple of questions I want to try to pick up on. So Sibu, do you mind presenting on the last case, which deals with resignation as a unilateral act? And it's the case of versus Morocco municipality.
Sure, thanks, Graham. Yeah, I think it's quite a lengthy case, and there's a lot that is covered in the case, but I think I'll just stick to what I feel is really important and just really concentrate on the principle from the case. Now, just a bit of background so that we can understand. There's three important names in this case. There is Munareng, who is the employee and the applicant. There is Mhlanga, who acted as municipal manager at some stage, and there is also Mungwe, who also acted as municipal manager at some stage, right? So those are the three names that I'll just focus on, which are of importance. Now, the employee in this case tendered his resignation with immediate effect on 1 April 2021. And when he tendered his resignation with immediate effect, he addressed it to Mhlanga, who then accepted that the resignation was with immediate effect. Now, some 2 weeks later, Munareng then tries to withdraw his resignation. Now, he had cited health, as the ill health as a reason for his resignation. So 2 weeks later, he tries to withdraw the resignation, and he addresses such withdrawal letter to Mhlanga again, and Mhlanga declines this withdrawal. So essentially, Mhlanga informs him that his resignation is still intact and he is still not employed by the municipality. Now, at some stage, Mungwe is then appointed as the acting municipal manager. This is around May or so. And when Mungwe is then appointed, as the acting municipal manager in May, he then advises the employee that he is accepting the withdrawal of the resignation. So this is more than a month later, and his notice period was actually a month. So he advises him that he's accepting this withdrawal. And when that is done, Mhlanga then instructs payroll to terminate any monies from being paid to the employee. So we've got one individual who has accepted the withdrawal and another individual who has not accepted the withdrawal. And so the applicant then comes to court, you know, because he wants to be reinstated into his previous position. He's claiming that he had resigned, but the resignation was then withdrawn. And that's really what the case is about. It's about whether or not that second withdrawal was effective or rather was valid. And in dealing with this case, you know, Mushwana goes through just the case law and the jurisprudence around resignation being a unilateral act, about the fact that once you have resigned, that terminates the employment relationship. And he goes on to say that, to his mind, when an employee resigns, you know, that's the end of the employment relationship. So he still seems to disagree with the latest and current jurisprudence on resignations, but he says that as a remark. And he says, if you want to come back, right, then essentially that act, when you send your withdrawal letter, you can only come back through re-employment. So your employer essentially has to rehire you. You cannot just come back willy-nilly. And he says in this case, especially because we are dealing with a municipality, the Municipal Act is very specific about what needs to happen and how appointments by a municipal manager have to be regulated, right? So a municipal manager cannot just appoint an individual without following the correct process. So he says that in this case, there was a withdrawal. The only way to come back is through being rehired, and the municipal manager in this case didn't follow the correct process of rehiring, and therefore he cannot place the employee back in his position, as the employee had resigned, and when he resigned, the withdrawal was not accepted at the time. He also then makes the point that, you know, being able to withdraw your resignation cannot just be open perpetually. It has to come at an end at some point, because we want to avoid a situation where people withdraw and then 2 or 6 months later, when their friends are in a position to accept the withdrawal of the resignation, they can do so. So he then says that withdrawal letter needs to come while you are still serving your notice period. Thanks, Graham.
Thanks. Interesting. Yeah. No, so there's been quite a lot of debate around this sort of resignation as a unilateral act, particularly in relation to people who resign without giving the requisite notice. And then whether that is the end of the relationship, or whether you can say to the employee, you are breaching your contract by not giving me notice. I'm holding you to your notice and you must work your notice period. And that's where the case law, the overwhelming case law, seems to have landed, to say that it is a unilateral act, but you can say to an employee who's in breach by not giving the requisite notice, you're in breach and I do require you to serve out your notice, and insist that they do. That seems to be where we are at the moment. So Zawadi, I don't know if you can do justice to your case in a few minutes, or whether you want to hold it over to the next session.
Yeah, I can. It's actually very quick, Graham. I can do it in about 2 minutes, actually.
Excellent.
Very, very good. Thanks so much. Thanks again, everybody. This case essentially deals with constructive dismissals. It's ShopRite, Checkers versus Ngosi and others. Now, there's nothing very unique about the fact of this case. I'm sure we've all experienced this at some point or some level. Essentially, the employee was, employed by ShopRite Checkers. And he, you know, had a series of challenges with his managers. He had, you know, claimed that he was intimidated. There was racist remarks. One of his managers said he would never be promoted as long as she is sort of his boss. So in short, it was just one of those, what he called a chaotic relationship. And in short, he resigned. He then referred a constructive dismissal dispute to the CCMA. The CCMA said that, agreed with him. It said that, look, this is definitely an instance where there has been constructive dismissal. Now, it was taken in review on the Labour Court by the employer. And the Labour Court really just touched on the jurisprudence of constructive dismissal. But the really important thing, and I just want to mention here, is what the court said is this. It said that the threshold, right, to prove a constructive dismissal case is extremely high, right? And courts or CCMA should readily accept that constructive dismissal has indeed happened. So an employer has to, or rather an employee has essentially several factors to prove. I mean, one of them is the fact that, one, he has terminated the employment contract. The reason was because it was an intolerable relationship. And most importantly, the employer played a material part in creating that intolerable environment. And in short, this is a very, very high threshold. In these circumstances, the employee failed. And one of the things that came to the employer's aid is the fact that it tried to play a role in amending this relationship. And it actually tried to take all the reasonable steps to ensure that he remains an employee of the organization. But yeah, the key takeaway is that extremely high threshold for an employee to satisfy the elements of a constructive dismissal case. Thanks, Graham.
Thanks again, Zawadi. So I am aware that there were a few questions that we didn't get to. I do apologize to the participants who put up those questions, but we had a very tight timeline. I'd just like to thank the panelists. Thank you for your contribution. I think you've done a fantastic job. Thank you for taking us through the cases. Thank you, everybody, for sharing the morning with us. And we look forward to seeing you at the next update towards the end of the year. Thank you. Cheers.
Thank you, everybody.